So the second panel is going to be about the state regulation of artificial intelligence. And I would like to introduce our moderator, Steve Tapia. Steve Tapia has practiced entertainment, media, and intellectual property law for over 30 years. As in-house counsel for DirecTV Sports Networks, he was the primary contract negotiator and rights manager for sports programming and distribution. He was also a senior attorney in Microsoft's Law and Corporate Affairs Department. So without further ado, Steve.
I will start by saying that we are dealing with a topic that has changed dramatically, and in some cases, almost overnight. I was asked by the school to teach a class in AI this last semester that we just finished. And I remember looking for material, thinking, with such a dynamic topic, how is this going to be possible? And I was very heartened to see that in October, that the Biden administration had released guidelines, and they look a lot like, for those of you that have dealt with trustworthy computing, you know sort of the standard pillars of it, of transparency, accountability, human oversight, all of these very, very standard kinds of policy decisions. And I blissfully went into the start of the semester knowing now that at least I had something to teach. We started our first class on the 20th of January. On the 23rd, the Biden guidelines were dissolved and sent into oblivion, along with virtually everything else that looked like AI regulation in the United States. And so we are here to talk today about what's left. It feels a little dystopian in some respects, but hopefully this esteemed panel will have the opportunity to share with you how it is that they see things. So let me just top line for you who we've got. We've got Matt Scherer. He's the Senior Policy Counsel for Workers' Rights and Technology at the Center of Democracy and Technology. Matt will be our first speaker. Sitting to Matt's left is T. Sannon, who is the Technology Policy Program Director at the ACLU of Washington. And then sitting next to T is Bisma Shoaib, who is an attorney with the Northwest region of the Federal Trade Commission. She's asked to remind us all that she's speaking on her own here, not as a representative of the FTC, and she probably also want to disavow that she was one of my former students. And sitting next to Bisma is Jay. Jaisimha is a Seattle-based technology entrepreneur with expertise in AI-enabled product development and data science. This is a very, very multifaceted panel that will have an awful lot to say on the subject. We'll start with, I've asked each one of them to do a very brief spotlight of what it is that they thought was important for you all to hear from them, and then we will have a nice chat. So first I've asked Matt, and then we'll hear from Jay, then we'll hear from Bisma, and then we'll hear from T.
So first off, my main area of focus is on the use of AI in worker and consumer decisions. So employment, housing, healthcare, and so forth. I had kind of been hoping that I would go last, so I want you to pretend that you're 40 minutes in the future and that you've already heard Jay talk about transparency, Bisma talk about antitrust, and T talk about civil rights, and now I'm zooming out and giving you a high-level overview. It works just as well as an intro, but so I'm hoping to get two things across in the next 5 minutes, and I thought that I was gonna be the most aggressive person to take the stage today. That turned out to not be the case. First, that states need to be more aggressive in their efforts to regulate AI and tech more broadly than they have been to date. And second, that the industry's arguments against state regulation are, shall we say, not well taken. And I do want to say hashtag not all industry. There are some reasonable industry groups out there, including actually Microsoft. I think that some of the more extreme voices are those like venture capitalists who are trying to burn down all efforts at AI regulation right now. I'll start with the first point about the need to be more aggressive. So states have fallen into the trap of passing what I would call performative legislation when it comes to tech. We saw it with data privacy, now we're seeing it with AI. The vast majority of bills that we've seen on those subjects are what I call legislative virtue signaling. They're bills often written or rewritten by tech industry or venture capital lobbyists that appear to address an issue of public concern, but whose provisions render it meaningless in practice. And I've got an article that I'll be posting to SSRN in the next couple of weeks called Against Legislative Virtue Signaling, Information Monopolies, and the False Dawn of State Tech Regulation. Keep an eye out for it. So this has been on my mind a lot lately. And the biggest thing that needs to happen is transparency, which is why I'm glad that you'll be hearing from Jay, who is one of the foremost advocates and experts on that. And we're living in an age where, kind of uniquely in human history, the most powerful industry in the world has exclusive access to key information that is needed to determine the risks that their products and practices pose to the public. And unless we break up that information monopoly, then tech regulation is never going to be effective. And the problem is that industry has every reason to do everything that they can to maintain those information advantages because, number one, polling consistently shows that the public is much more concerned than they are excited about AI. In fact, one really particularly striking poll from, I believe it was Pew a couple of years ago, showed that a plurality of people do not even want AI to be used to help make decisions about major things in their lives. If you were to put a ballot initiative pretty much in any state in the country today saying, do you support a ban on the use of AI to decide whether you get your next job, it would pass with probably 80% of the vote. And not to mention that as long as companies can keep their AI practices hidden, they don't have to worry about little things like checking to make sure that they're not violating anybody's civil rights or consumer protection laws or labor laws. If AI legislation doesn't break those information asymmetries, which are really information monopolies in a lot of cases, legislation is not going to protect anyone. You need legislation with broad and clear definitions, robust transparency requirements, and no loopholes, all backed by strong enforcement, or at best what you're going to get is paper compliance. Unfortunately, what we've mainly seen with data privacy and now AI legislation is legislation with narrow or ambiguous definitions, weak transparency requirements, lots of loopholes, and frankly, useless enforcement. And any one of those is enough to render a law meaningless. And we saw that play out with New York City's AI and hiring ordinance. I would encourage you to Google, there's an article called Null Compliance that discusses this, which companies have been able to basically ignore because of a combination of vague definitions and weak enforcement that give companies basically the ability to decide whether or not the law applies to them. Guess what answer they usually reach? Meaningless laws like that, I would argue, are worse than no laws at all. It derails efforts at effective regulation, and in fact, in many of these cases, such as a privacy bill that was written by Amazon and then copied into a bunch of other states, it is explicitly designed to preempt meaningful regulation. Second, it allows potentially harmful practices and technologies to proliferate so that later efforts to regulate them are more disruptive. But the most liked Blue Sky post I ever made said the tech industry only ever has two positions when it comes to proposed regulation. One, it's too early to regulate us, our tech is still developing. Two, it's too late to regulate us, our tech is everywhere. And then finally, it undermines confidence in the ability of democratic institutions to rein in powerful industries when you pass legislation that the public sees has not done anything to change their practices. So we don't have to solve all the world's problems at once, but legislation is only worth pursuing if it provides meaningful protections. And with that, I want to give a shout out to Representative Shelley Kloba here in Washington, who has been pushing strong privacy legislation for years. Any number of times she could have taken the easy way out and passed a virtue signaling bill, but that wouldn't have protected consumers. So props to her for standing her ground on that. Now I want to turn to why the usual arguments against state legislation are wrong. The first you'll hear is, don't hinder innovation. Here's the thing. If the success of your product is dependent on keeping consumers, regulators, workers, and the general public in the dark on the risks that it poses when it's being used and how it's being used, number one, I'd argue it's living on borrowed time. But number two, that's not real innovation. Real innovation is technologies that people trust and see the benefits of. That's what's actually going to stick as an innovative product. I'll also point out that every time we've heard the argument of don't regulate a technology, you'll hinder innovation, it never pans out that way. The second argument is that states shouldn't act because it could create a patchwork of regulation that is costly for businesses. I'm sorry, I used to be a corporate lawyer, and that's hogwash. If states have different rules, you align your practices with whichever one has the strictest rules. What you're saying is that you don't want to do that. So once you stop and think about it for a split second, you realize that the patchwork argument is really just an argument for weak regulation rather than consistent regulation. The best evidence for this is actually what happened with privacy laws. If the tech industry hated patchworks, then when California passed its privacy law in 2018 and 2020, they would have encouraged every other state to adopt it. Instead, what they did was they wrote their own privacy law, got another state to pass it, and then when that actually proved to be too extreme in the other direction for other states to copy, they found yet another model and started selling that to other states. They created the patchwork in an effort to head off meaningful regulation. So they're not actually concerned about the patchwork. What they actually want is weak regulation. Again, though, hashtag not all tech companies. With that, I do want to close with a quote, though. And this is the most aggressive part. The interest of the dealers in any particular branch of trade or manufacturers is always in some respects different from and even opposite to that of the public. The proposal of any new law or regulation of commerce which comes from this order ought always to be listened to with great precaution and ought never to be adopted till after having been long and carefully examined, not only with the most scrupulous, but with the most suspicious attention. That might sound like it was Karl Marx. It was actually Adam Smith from On the Wealth of Nations. Thank you.
Yeah, I was introduced as a technology entrepreneur. Please don't hold that against me. I haven't been doing that for a couple of years now. And a couple of years ago, me and another colleague of mine ended up founding the Transparency Coalition because we saw, so I'll tell you a little bit about what we do. I'm literally in the trenches with on state AI policy making. I was in Sacramento the entire day yesterday testifying. Was in DC a couple of weeks ago. So it's literally, there's a lot of interesting trends in AI regulation in the states, and I just want to maybe do a short survey of what's happening in some of the states so you can at least understand. So I think concerns we and others are reacting to are, of course, products that are becoming more addictive because of AI. Or AI being embedded in them specifically on social media, but now increasingly on chatbots as well. You're starting to see, because I think part of what you hear very often is, well, there's not evidence of widespread harm. I'd argue that it's happening in real time to all of us. The use of, more people use chatbots, including children. And then, of course, the prevalence of deepfakes. You've probably heard of many instances of deepfakes generated by AI being used to cyberbully students or other teenagers. Evidences of financial and other types of scams that are performed using deepfakes that are AI generated. So it's definitely real dangers that are there. And what we discovered is that when we started our organization, is that in every state we went to, there were policymakers. There were a large number of civic society organizations, researchers, and partly this is an attempt to recruit new colleagues from the Seattle University campus for me. But really, I think there's a huge gap where a lot of policymakers don't really understand where to go for the latest in either the technology side of things or the policy side of things. And so we try to act as a bridge builder between the two. We do a lot of work with Matt's organization, for example, but also with a number of other organizations, all focused on this type of policymaking. And this is where I think maybe we're a little different from Matt's organizational philosophy. We realize that many of the people we talk to, they're not necessarily virtue signaling. They have big intentions. They just don't know how to get it done, or they don't have their colleagues on board yet. So we understand that change is a process that takes time. Time is not always on our side, but we want to make sure we engage with policymakers where they are and take information to them that'll help them make rapid incremental progress on AI legislation at the state level. So that's kind of our goal. So the two main areas that we focused on from a transparency perspective, and this is in 2024, we helped enact 2 laws that were the first in the nation transparency laws in California. One was a nutrition label disclosure for training data, necessary but not sufficient, I might argue. And then the second was a law that requires AI-generated information to be labeled so people could actually tell they're generated or modified using AI. So both these laws were signed by Governor Newsom last year and will be in force first of the year. Because California is such a large state has such a large impact, we're expecting companies to abide by these as kind of a good baseline, since no equivalent laws have passed elsewhere in the country yet. Now I'm going to sort of jump into a bit of a survey of what's happening in 2025. So I think a lot of our efforts in this year, we've seen a lot of efforts around expanding on the definition of generative AI training data transparency. And here, the idea is that training data is the data that is used to build a model. And very often, unlike even some of the predictive AI models that are used in decision making, these models tend to really derive a lot of their value from the training data and the structure of the training data. So getting more transparency into that is super important. One of the bills I'll just highlight that's really breaking new ground in this session is a bill called California AB 412 that's focused on expanding copyright holders' visibility into how their data is being used by a model. There's massive evidence of, I'm sure if you've authored a manuscript or a book, chances are that that book has been ingested and is now being used powered models for which money is being charged. And this bill will actually let you hopefully be able to gain visibility into if that's being done or not by a model developer. The other area that's really interesting is around consumer warnings or notifications. Arguably insufficient. I mean, sometimes the warning is actually an incitement for increased use, but certainly there's warnings that there's a number of bills. I was testifying on behalf of California SB 11 just yesterday morning. And the goal here is to try to warn people against misuse or against the actual harms that might accrue from the use of a chatbot, for example. Senate Bill 243 from Mr. Padilla in California and the bill from New York are both kind of groundbreaking attempts to try to educate people about the dangers of using chatbots. And I think that part that we haven't seen much evidence of yet, which is, treating AI as a product, because I was listening to a panel discussion yesterday and people were talking about the importance of, if you can't really understand what's in the inside or if people aren't willing to tell you, one of the most powerful ways is to let the industry figure it out. But for that, you need the hammer of product liability and a volume of people pursuing that. And so we are really interested in ensuring that product liability frameworks take their place in helping push AI regulation forward. That's it, and I look forward to the rest of the discussion.
Good afternoon, everyone. It's really nice to be here. The disclaimer Professor Tapia already gave, and if I get anything wrong today, I have several of my professors here, and you can blame them for it. So today we're really talking about a disruptive technology, innovation, what the world is going to look like 5 to 10 years from now. And I'm asking you to trust me a bit and go back to the 1800s. In the 1800s, we had these large businesses that essentially controlled entire segments of an economy. They were called trusts, and what became apparent was that they exercised monopoly power, also enjoyed monopoly profits at the expense of consumers. They also had significant economic and political control. In response to that, in 1890, Congress passed the first federal antitrust law, the Sherman Act, which was also the first federal antitrust law in the world. I'm going to briefly in the next slide cover these laws, but in the 1914, Congress passed the Federal Trade Commission Act, which created my agency, and also the Clayton Act. The goal of these laws is really to safeguard competition, and I've highlighted some language there. On a very high level, the Sherman Act outlaws every contract, conspiracy, and restraint of trade, which is really unreasonable restraint of trade, and monopolization, attempted monopolization. The Federal Trade Commission Act bans unfair methods of competition, something that is very, I think, incredible, might be biased about the FTC Act, is that it doesn't just cover the Sherman Act violation, but goes beyond it to cover conduct that might not neatly fit into the Sherman Act. Then we also have the Clayton Act, which prohibits mergers and acquisitions that might substantially lessen competition or create monopoly. And from the language on the slide, I hope it's clear how broad it is. It doesn't describe the market, it doesn't describe the specific conduct, and the effect of such a broad language is that the antitrust laws have been applied from the era of horse-driven carriages to today's digital markets. There is no AI exception to the antitrust laws. So I think it's nice to have this overview to understand the umbrella under which AI markets operate. So why should we care about antitrust and AI and their intersection? Because there are some significant antitrust concerns that might come up when we talk about AI. One of them is control of key inputs. When a small number of firms control critical inputs, and that could be data, that could be substantial compute, it can really stifle innovation. Example would be when large tech firms already dominant in the market have proprietary technologies or just a host of data already collected. And the danger there is that the control of inputs can create barriers to entry and also expansion. Another critical input for AI space is labor. And developing AI models require highly specialized workforce, which is not just high in demand, but also could be rare. So large firms, dominant firms might be incentivized to lock in workers through restrictive contracts or exclusive arrangements, which can have substantial impact on the mobility of labor force and also how rivals compete in the market for AI. Other potential concerns are consolidation of market power. So I think most folks in the room are aware of partnerships, joint ventures, M&A activity in the AI space, which can be beneficial, but may also raise significant competition concerns. One key aspect is really vertical integration, where dominant firms might control, again, critical applications or input. There are also several other antitrust concerns. One of them is collusion, AI-based price fixing. So price fixing for decades has been held as the great evil under antitrust laws. Just because it's done through AI does not make it legal. But why does it matter? Why should we think about antitrust when we think about AI? And it's something that I think multiple speakers before me have also said, that unchecked AI markets can be really detrimental to economic and democratic freedoms. And competition law is a tool that we can use not just to lower prices and for a higher quality of product, greater innovation, but also because free and open markets are really a hallmark of a functioning democracy. That was true in the 1800s, and that is equally true today. So the key takeaway from me today would be, when we are having these discussions about how we should govern AI, is to remember that tools from the 1800s and the 1900s are effective and very much needed today as well.
Just to recap, as the person who's going last, T. Sannon, Technology Policy Program Director at the ACLU of Washington. Excited to be in conversation with you all today. So I want to focus on the fact that while it's clear that AI has a lot of promise and potential to improve people's lives, there's also a lot of potential for harm, a lot of harm that we're already seeing. And so I'd like to talk a little bit about what these risks and harms are on a concrete level, and start thinking about what the regulations could look like to address them. Really to answer the question of, how do we make sure that the opportunities that are offered by AI are distributed on an equitable level that advance equity across populations, across groups, and also protect civil rights and liberties rather than violating them. As everyone has shared already, AI now cuts across major life domains, several domains that it helps make critical decisions over. And so there's a range of implications for people's rights and equality and livelihood that is very fundamental and very real, from healthcare and education and policing, employment, etc. So a few of the key risks and harms in these spaces for civil rights and liberties are privacy violations, so the mass data scraping, the use of AI in surveillance, often without people's consent or knowledge, issues with accuracy, so a lot of AI systems, for example, facial and emotion recognition software, has been shown to be very inaccurate, especially when it comes to recognizing faces of people of color, to very detrimental and sometimes life-threatening consequences. And then also the risks of bias and discrimination, given that AI has the potential to not only replicate existing inequality, but also reinforce it. And as Sonia Katyal already shared with you, this bias can enter at every stage. So there's the data bias when the training data reflects past inequalities. There's issues with model design that ends up showing up as algorithmic bias, and then also deployment bias, where the systems may seemingly be neutral on the surface, but then end up deepening discrimination based on how they're deployed and unfair use. And these risks and harms aren't just hypothetical anymore. We're seeing a range of real-world examples of this discrimination in banking, in healthcare, wrongful arrests of Black men in Detroit and in Atlanta, across the country, based on faulty facial recognition software, or hiring tools that downgrade resumes if they have words like women's groups on them. Healthcare that's held back from certain groups, especially Black women, if the algorithm is basing its decisions on who gets healthcare based on a proxy that ends up being a proxy for race, even if it's unintentional. And so I'd like to go into just a few of our recommendations around what regulation could look like around these issues, to just start tackling these real issues that we're seeing. And the first one is transparency. And transparency I see as really the place where everything else flows from. And without transparency, you can't have meaningful accountability. You can't really have meaningful regulation, because you need to have at least a sense of what's going on before you can address or even know that harm is happening, before you can exercise your rights, etc. And so some of the kinds of policies in this space would be mandating disclosures of AI use so people know when they're using AI, which is something that often don't know, requiring people to have understandable explanations. So if you're having an AI system make a decision that is going to have some kind of critical impact on your life, that's something that person should have a right to know that an AI was involved in that, and then also a right to recourse to challenge that decision. So transparency in that sense, obviously the transparency that Jay has already talked about in terms of data sets and data, and also providing public access to audits. And I'll talk a little bit more about these audits in the next slide. The second policy recommendation broadly is around impact assessments. And this goes back to the idea that bias creeps in so many different places unintentionally, given that we live in a world that is rife with inequality. And when you deploy tools that are trained on the real world, they are very often likely to pick up these existing inequalities, even if you may really not intend for them to do so. And so these impact assessments could come in many different forms across those upstream and downstream places where bias could come in. And so, for example, before deployment, having civil rights risk reviews, both in government, but then also in the private sector, especially when it comes to technological contexts that are going to have very consequential decisions about people's lives. Requiring independent, ideally bias and fairness audits by third-party auditors, and then also having an ongoing monitoring system for high-risk uses of AI. And that provides a check at every single stage, ideally to try and prevent this harm from happening in the first place versus other approaches that end up being more around cures than prevention. And so I think the impact assessments are really important to think about because of the degree of harm that can take place. I don't think that it's a responsible AI practice to sort of regulate in a way that the harms are only addressed after they take place rather than prevented in the first place. That sentence got away from me. And then the third policy recommendation is around just strong enforcement mechanisms. So, all of the policies that we throw out are great, but they aren't really meaningful or effective if they don't have robust enforcement mechanisms. That's what gives them teeth. A few of the things that in Washington state that we've had get passed in some consumer privacy laws, like My Health, My Data, have included a private right of action. That's something I think that is really critical in the AI space as well for affected individuals to be able to actually exercise their rights and get recourse, as well as dedicated funding for enforcement agencies and other penalties that deter and correct discrimination. And I'd like to end by just saying that, there's a lot of talk around the idea that regulation stifles innovation. And I'd like to challenge that by saying that this kind of regulation and responsible AI deployment and development really is a way of building trust. And right now, multiple surveys of public opinion on AI show that public trust in AI is woefully low, with good reason. And I think that with these kinds of guardrails, it's really about thinking about how do we make sure that these promises and all of this potential that everyone's excited about with AI does actually benefit everyone without these many different types of risks and harms that are taking place. And that's something that I think you can't do unless you really center a consideration for civil rights right at the center of both the design of the technology and around regulating it. That's it. Thanks.
Thanks. Excellent. Just an observation and then a couple questions that I'd love to get the thoughts that the four of you have on them. The first observation is several of us were involved in a very similar discussion a few weeks ago, and while it seems that we have a tendency to consider ourselves chicken littles running around saying the sky is falling and AI is already out the door and it's we're only 2 steps away from the Terminator scenario where the world is going to end. It is good, and I think all four of you touched upon that there are existing laws out there that still have a very, very strong strong resonance in terms of what it is that we're doing. A car hitting someone in a crosswalk is still a car hitting someone, whether it's an autonomous car or whether it's not. And so while there are these strictures that we have, and while I think technology likes to pretend that there's a lot more black boxes that just can't be penetrated than there are still things like antitrust law and the things that T was talking about at the end that we can borrow from other disciplines and bring to bear on that. So that, I think, is somewhat of the place where we start off as a launching point. But let me ask you this. By my count, in my either studies or my lifetime, this is the 4th time we've been through this cycle. Matt and I were talking about this just before we started today, that you see this introduction of technology that looks like it's going to be incredibly democratizing, and then all of a sudden there's an inflection point where people realize that it's very expensive. And as it gets more expensive, it falls into the hands of people that have money, not strangely enough. I mean, we saw this with the ramp up around personal computing. We saw it with the ramp up around the internet. We've seen it with what happened with privacy. And we've also now, we're encountering it with an AI. So in internet law, they talk about it as a period of internet exceptionalism where everybody thought, wow, this technology is just amazing. And then all of a sudden, for all intents and purposes, the internet was run off by 6 different companies. And we've been living with that ever since. And I'm reminded by something that a colleague of mine said at a conference when the European data privacy regulation was coming into play, where she sort of said, look, you can make all the policies in the world that you want, but unless you make it so that a computer can understand it, which means yes or no, they're all worthless. And I won't go quite that far, but we are in a situation where as lawyers and as social scientists and as policymakers, we deal with a lot of things in the land of ambiguity and gray areas, and computers don't have gray areas. If they do, they crash. So with that in mind, and realizing already that we've seen that AI has sort of really become the massive amount of money invested, it has made it so that it's in the hands of 5 or 6 different companies. Where do we start? Where do we start right now in 2025 with getting effective ways of regulating? I'm mindful of the fact too that this is an industry that has as its dual patron saints the Grateful Dead and Ayn Rand, right? You know, on the one hand, it's like anything that is traditional and orderly is something that we want to stay away from. And on the other hand, Ayn Rand saying, you know, regulation, get out of my way, I know better than you, which almost sounds like a direct quote from Steve Jobs. But where do we go?
Can I start?
Sure.
Yeah, I'm old enough now to actually have lived through the personal computing revolution, the start, the hype, and the end of it, or, you know, transition to the internet. And so to some extent, I'm expecting some aspects of a hype cycle to happen to AI as well. But I think that, you know, all of us have mentioned the word transparency, I think, at least once. And I think that more transparency is called for. Unfortunately, we're in the situation where transparency is also, you know, the issue around trade secrets is a big one, and it's now the question is, you know, when people invoke trade secrets as an alternative or an argument against transparency, what are they doing it because they're hiding, you know, some malfeasance, or are they doing it because you know, they're interested in preserving their market position, and other people who are advocating for transparency are just trying to steal the crown jewels? So who knows, right? That's something only time will tell. But I think many other, I think the push around transparency is one. I think there's an increased awareness of the importance of third-party verification of transparency claims. I think that's super important. There's quite a few other industry-driven, I won't call it, I know that's the subject of the next panel, is industry self-regulation, but there are marketplace mechanisms around internet standards or cybersecurity standards where there's a thriving ecosystem of people who develop the standards, people who verify compliance, and companies view it in their own personal self-interest to actually abide by them, because other people will not buy your products if you don't do that. So I think until we get to that point, we need to jumpstart that cycle a little bit with some skillfully planted either procurement laws, I think it was one that was invoked earlier, or other ways to try to get people, you know, to start opening up, knowing that over time it's going to be okay, and there will be business to be had, even if you abide by regulation.
I think from an enforcement standpoint, enforcers and scholars are both acutely aware of not repeating some of the mistakes, perhaps, that were made during the tech boom, and really learning from that, which is why I highlighted the 3 federal antitrust laws, but it's also important to recognize that states have their own antitrust laws as well, and given different state policies, they might be more aggressive or more lenient, but even on the federal level, from a competition standpoint, we're at a very interesting place where we essentially have bipartisan support and recognition that big is bad if we're looking at tech or AI, and that it's something that we didn't have in the past. It's something that we didn't see with the rise of social media and tech companies. So I do think historically we are at a different point in terms of how we will apply the antitrust laws to AI markets. There's also bipartisan support for and focus on labor markets, recognizing that AI may be very disruptive to labor force. I think from an antitrust perspective, we're at a very interesting space where we might see enforcement and potentially correction of some of the mistakes that we might have made in the last 4 decades.
I do think it's a great point that there does seem to be bipartisan concern both about the bigness of the tech companies right now and also just in general concern about AI. One of the most interesting things is that the 2 loudest groups of voices against the AI moratorium have been the Congressional Progressive Caucus and the Congressional Freedom Caucus. On that note, I don't think that what I refer to as legislative virtue signaling arises because legislators go in and think, ha ha ha, I'm going to pass a useless bill and nobody will know the difference. I think that it's because they genuinely want to do something and industry groups give them what seems to be an easy win. And the problem is, to me, all goes back to transparency. It's a dead horse that I'll just keep kicking. And, we do have these existing laws and we do have the antitrust laws are among the most powerful tools, so are civil rights laws, but none of them work effectively if we don't know what data the companies have, what people they concern, what decisions are being made using them, how they're using these different technologies, what companies are using them, when and why. All of this information, which they jealously guard using trade secret doctrine, misusing trade secret doctrine, I would argue. Professor Katyal can speak much more expertly on that than I can. But that's the first barrier that needs to be overcome. And it's a really tricky one because how is it that you verify that tech companies have provided the information that they have in their possession that is relevant to something? That's a really difficult problem. They have exclusive access to it. You kind of need those whistleblowers under the Defending Trade Secrets Act. But when you've got an industry that is throwing $10 to $100 million bonuses at AI engineers, how many of them are going to blow the whistle on their employer and provide that information that's necessary for the general public to know about the risks of those products? I have some half-baked ideas on how to do that, but it's a really tricky issue, and that to me is the first thing that needs to be overcome for any meaningful regulation to happen.
Yeah, so I would echo, I think transparency is absolutely where we need to start. There's just so much that we don't know. And I think that we're seeing across states this, sense of urgency to regulate on AI. And I think we have to be really careful that while regulation is absolutely needed, and I presented a few things I think are really, really critical, we also need to do a lot of information gathering to have a sense of, what the next steps are. And so I think transparency is absolutely the way to start to get that. And then separately, I think there's a real need to start placing limits or prohibitions on certain types of AI use that we know concretely from extensive research that are really dangerous, where the risks really do completely outweigh the benefits. And so, for example, I'm thinking about the facial recognition ban in King County. I think that some of those steps could, at least for now, mitigate or prevent some of the biggest harms, the most dangerous harms that we're seeing with AI as we keep aiming to regulate the rest as well.
Yeah, it's interesting. I know that I'm always mindful of the fact that when lawyers talk about empirics, most humans would call them facts. But there seems to be a movement to try to gather together empirics around some of this stuff. And so, for example, in copyright infringement, so some of the copyright scholars have noted very, very well that when courts are being asked to shut down a particular aspect of a technology, they're very reluctant to do that, rather than try to come with another way of either stepping in, in the case of things like news websites disappearing, revenue sharing, and things like that. So it's kind of interesting to sort of think that even the courts, in some respects, may not be the last bastion of what it is that we can do to try to move. But let's pivot in that direction. Okay, we know transparency. We also know, I won't mention any names, but Meta comes to mind. Big actors will say, yes, we're going to do better, and then turn right around and do whatever it is that they want to do. And as I think, Bisma, it may not have been the semester that you were in my class, but we tracked how many times they did that in one semester. And we stopped counting at 14. But you've got, so what's that enforcement mechanism look like? How do we get people to be good citizens? I mean, each one of you has a magic wand. What's that first step that we take?
I mean, I think one of the things I'll point to again is the importance of liability law. I mean, I'm in a room full of mostly lawyers here. We don't have a clarity around whether AI is a product or a service. The process of establishing that AI is indeed a product, is establishing that in law would be very helpful, I think. And that would then, I think, make it a little bit easier for harms to be potentially punished, by courts. And then certainly that in turn could make people a bit more open to having reasonable conversations. Right now, all claims of reasonableness aside, and I don't think any company is free of this, just based on our own experience in advocacy, literally every bill, regardless of what it claims to do, is adamantly opposed by every industry group imaginable. Typically, it's not directly people from companies speaking, but just the firsthand experience we have when you're in a legislative chamber is group after group, and I think Matt and I have talked about the number of different organizations that all are potentially backed by the same companies that show up and say no, 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 no. So something has to get them to the table before reasonable laws can be passed. And I think one hope is that maybe product liability legislation or product liability litigation tied to AI might be one way to get people to talk. I mean, I think it's obviously, all of us are dreaming about silver bullets. One other thing I'll also say just briefly is that very often we're also stuck because we're looking at two very different types of AI, right? A lot of the discussion around facial recognition, technologies used for potentially scoring applicants to jobs, very, very different from the generative AI models in some respects, right? And so the way they're used, the way they're deployed, who gets to use them, but at the same time, people that are only focused on generative AI in their businesses show up to fight against any helpful legislation in the sort of machine learning side of things. And so that also complicates things. Again, I'm sorry, I know you asked for a solution, so I started with a solution, and now I'm in the woe is me part of my speech. So,
I actually, I'm going to speak for 10 seconds and then pass it off to T because I'm basically just stealing her slide. But that slide said you need a private right of action, and or you need an enforcement agency that has the resources to actually enforce the law. And there's actually been empirical research done on what effective enforcement looks like. And the main thing that matters is how frequently violations are detected and successfully enforced against. You can have penalties be as high as you want, but if a company is only going to face a lawsuit 1 out of 100 times, they're going to roll the dice and go with non-compliance if it's more profitable for them to do so. There's plenty of examples of this that I could cite to, but again, I'll turn it over to T because I'm essentially stealing her slide on this.
Oh, thanks for that summary, Matt. Yeah, private right of action. This is my horse that I keep beating as well. But yeah, and I think one of the things that we keep hearing as pushback is, this worry about frivolous lawsuits. And I think we've seen in the few states that have really strong laws around, for example, privacy with a private right of action, that concern hasn't really come to bear. And so that's just the little piece that I'd tack on there.
I'll steal another aspect of T's presentation. I think resources are a key aspect, funding enforcers. One of the things I really like saying to opposing counsel is that if you break a consent order, we will come after you. We can't do that if we don't have resources to do that. So having advocate resources for enforcers is important.
Yeah, I think the one additional comment is in many bills are being written today with the AG's offices being tasked with enforcing things as a way to get out of adding a private right of action. But the flip side of that is that AGs are also political officials, and so the appetite to actually enforce laws may be mixed.
And I would add, we've seen bills where there are impact assessments that are only available on request from the AG's office, and that just puts an immense burden on the AG's office that is just unrealistic for them to, put out these proactive requests to the, hundreds and thousands of companies that are using AI to audit them. And so, yeah, definitely, I think the flip side of that is having these stronger requirements around things like impact assessments so that they're something that the company has to provide, which also then lessens that burden that currently is being placed unrealistically on agencies.
The last thing that I'll say, and this is one of the half-baked ideas that I mentioned, it may ultimately be necessary, we may ultimately conclude that it's not enough to simply have traditional enforcement mechanisms when it comes to companies that have such an immense information advantage, that they know so much about us and we know so little about their practices. The half-baked idea that I have is there might be a need eventually for something akin to mandatory reporting inside these companies, where if the employees inside the company become aware of an unlawful use of a product or a failure to disclose key things that a law requires them to disclose, that they have to inform a regulator, that they have to blow the whistle. There are examples of that. That is one of the mechanisms that exists to prevent money laundering in the financial industry, is that you have reporting requirements like that. So there might need to be things that sound radical when we say them out loud right now, but again, just given the kind of unique ways in which these companies have an advantage over ordinary people, something pretty radical might be needed in order to balance the scales.
Excellent. Well, thank you, all four of you, for your wonderful contributions today and for taking the time to join us. Thank all of you for sticking out through the afternoon. It's a somewhat beautiful day outside, so I know that you're here voluntarily. And we deeply appreciate your attention and your concern. Please join me in thanking our panelists.